Good morning. Today I'm going to discuss an interesting case, recent decision of Justice Ball sitting in the Equity Division in the Supreme Court of New South Wales. The case is called Lindsay-Owen and Schofields Property Development Proprietary Limited, 2014, NSWSC 1177. And the case is particularly interesting. It's a fairly complex contractual dispute about whether certain monies are payable under a joint venture agreement. But the case is interesting because Justice Ball in it provides us with a very up-to-date summary of the recent position with respect to contractual interpretation. And he needs to do that because there are various arguments being put with respect to the way in which the contract should be construed. And of course parties are arguing for their own particular position, which would have resulted in certain monies being paid under the joint venture agreement. And as His Honour says at paragraph 46, the principles relating to the construction of a commercial contract are not in doubt. And you'll recall, of course, that the High Court has looked at this area in some detail very recently in a short case called Electricity Generation Corporation and Woodside Energy, 2014 HCA 7, which is at 306 ALR 25. And in paragraph 35, the High Court said, this court, that's the High Court, has reaffirmed the objective approach to be adopted in determining the rights and liabilities of a party to a contract. So, no doubt, no need to look at any subjective intention of the parties. We look at the objective third-party view of what the parties seem to have decided. And how do we look at that in a commercial contract? Well, the meaning of the terms of a commercial contract is to be determined by what a reasonable business person would have understood those terms to mean. This is the High Court. That approach is not unfamiliar. As reaffirmed, it will require consideration of the language used by the parties, the surrounding circumstances known to them, and the commercial purpose or objects to be secured by the agreement. And in order to appreciate the commercial terms or objects, you can look at the genesis of the transaction, the background, the context, and the market in which the parties are operating. And the court looks at the decision of Lady Justice Arden in Re Golden Key and points out that unless a contrary intention is indicated, a court is entitled to approach the task of giving a commercial contract a business-like interpretation on the assumption that the parties intended to produce a commercial result. Well, it's all pretty self-evident, I suppose, isn't it? And it follows from that a commercial contract is to be construed so as to avoid making it commercial nonsense or working a commercial inconvenience. Okay, so we've got an objective approach. We need to look at the context, and we need also to look at how the contract was generated. Now, what can't the court look at? This is where the matter gets more confusing. Paragraph 47, Justice Ball notes in Lindsay-Owen that the court may not have regard to the negotiations between the parties for the purpose of determining the correct construction of the contract, except to the extent that those negotiations establish objective facts which were known to both parties and which therefore form part of the context in which the contract is to be interpreted. Alright, so a fairly subtle distinction there in a sense. You can't look at what the parties said prior to the contract being formed unless those negotiations actually set up an objective regime in terms of facts which both parties know and which therefore form part of the contractual matrix, if you like. And Chief Sir Anthony Mason said something along those lines in Cadelpha Construction and State Rail Authority, the famous High Court case, which is the usual starting point for questions of construction. Cadelpha's case, remember, is in 1982, High Court of Australia 24, 149 CLR 337 at 352. And there, at 352, Sir Anthony said, prior negotiations will tend to establish objective background facts which were known to both parties and the subject matter of the contract. To the extent to which they have this tendency, they are admissible. But insofar as they consist of statements and actions which point to their actual intentions and expectations, that's of course subjective, then they are not receivable. The point is that such statements and actions reveal the terms of the contract which the parties intended or hoped to make. They are superseded by and merged in the contract itself. And this of course is why when we're looking at evidence we learn the parole evidence rule. The object of the parole evidence rule is to exclude them, the prior oral agreement of the parties being inadmissible in aid of construction, although it may be admissible in an action for rectification. So, if we're looking at what people said before the contract was formed, we've got the basic doctrine that we've got a parole evidence rule which excludes earlier prior statements. We don't admit those. We look only at the written document. And there's a notion of merger or supersession in the actual contract, the written contract. And the written contract, of course, is what the court is construing. Sir Anthony in Cadelpha did, however, note one exception, one possible exception. He said there may be one situation in which evidence of the actual intention should be allowed to prevail over the presumed intention. If it transpires the parties have refused to include in the contract a provision which would give effect to the presumed intention of the persons in their position, it may be proper to receive evidence of that refusal. After all, the court is interpreting a contract which the parties have made, and in that exercise the court takes into account what reasonable men in that situation have intended to convey by the words chosen. Alright, so the court can't look at matters before the contract, and paragraph 48, as Michael Ball points out in Lindsay-Owen, the court generally may not have regard to subsequent conduct of the parties interpreting the contract. And the High Court authority for that is Agricultural and Rural Financing and Gardner, 2008 HCA 57, 238 CLR 570. However, evidence of post-contractual conduct may be admissible as an admission to prove a fact which is relevant to the parties' contractual obligations. Right, so if there's an admission against interest in some post-contractual statements or negotiations, then that evidence may be admissible as an admission against interest, I suppose. And the relevant fact may be what was said where the contract is an oral one. It may also be a fact that forms part of the context in which the agreement was reached, a fact concerning whether the agreement was reached, or a fact concerning whether the agreement was wholly in writing or is to be found in conversation between the parties as well. So you can see there is a possibility in relation to post-contractual statements of perhaps getting the evidence in. Now in this case there are questions about whether or not under the joint venture agreement certain repayments of a large loan, had to be one of the banks, the big trading banks, had to be made out of monies being payable, and His Honour then looked in great detail at the various evidence and came to a conclusion about that, concluding that it was not covered. His Honour also looked at the question of rectification, and he looked first of all at the question of rectification if there was a mutual mistake with respect to the terms of a contract, a written contract. In order to make out a case for rectification of mutual mistake, it's necessary to establish in the clearest and most satisfactory manner, or by clear and convincing proof, that at the time they executed the joint venture, in this case, the parties had a common intention concerning their agreement which was not reflected in the written contract. The mistake may be a mistake concerning the effect of words that were chosen deliberately, and the common intention must be capable of clear expression. And in order to ascertain the parties' common intention, the court can consider the negotiations between them. And it may also, in that situation, consider evidence of the uncommunicated subjective intention of the parties. And the case for that is the well-known decision of the Court of Appeal in Rydaldar, RYLEDAR Proprietary Limited and Euphoric, 2007, NSWCA 65, 69 New South Wales Report 603 at 176 to 187 by Justice Tobias, Murray Tobias, and Joe Campbell's judgment is at 258 to 316. Keith Mason agreed with both of those judges. So you may, for rectification, look at the uncommunicated subjective intention. If a corporation is involved, then you've got to look first and foremost at the primary intention of a state of mind of the person who acted. So that's if you've got a mutual mistake. Clear evidence, you can look perhaps at subjective intention. It's got to be capable of clear and accurate expression. What about if it's a unilateral mistake? That's what the parties were arguing here. One party was saying that in this case it was quite clear that the bank debt was to be repaid from monies advanced as the contract unwound the development. The other party said no, it's your own behoof, you've got to pay it yourself. Well, as Michael Ball says in paragraph 70, the circumstances in which a court will grant rectification for a unilateral mistake are less clear. However, at a minimum they involve one party operating under a mistake and the other party knowing of that mistake and contributing to it. And in this case, just on the facts, His Honour concludes that there are insuperable difficulties to the plaintiff establishing that particular position. Alright, so an interesting case, as always a very concise judgment which sets out the law very clearly from Justice Ball, and a case well worth reading because it provides a very useful summary, I think, of two important areas. First of all, how we construe contracts generally, commercial contracts, and secondly, what are the requirements if we seek to rectify those contracts on the basis first of a possible mutual error, and secondly on the basis of a unilateral mistake. And obviously a unilateral mistake is going to be far more difficult than a mutual mistake for rectification purposes.